Okay, all right. The next part of our family law primer, we start getting involved in individual kind of cases, and more than anything else, the driver of family law is going to be custody cases. Custody cases are usually what spikes people into hiring an attorney. They kind of think, well, I can handle a lot of the different parts and those things, but when things become a conflict with the children, that's when filing begins. I think that sort of get that feeling of like, okay, I cannot do this anymore. My kids need to be a part of that. So, I think that when you're talking about a custody case, you're certainly talking about some emotional issues. And a lot of times what you're doing is trying to explain to the client as to what their expectations are going to look like, what that might be, whether it's realistic or not. A lot of times the clients that have the best custody cases are also some of the most difficult clients because they believe that they should be the primary caretaker. The issues sometimes are anything less than a full custody, and in their mind, the children being with them all the time is a loss. And sometimes some of the worst kind of clients are the ones who are happy just to get a very small amount of time with the children. So they become some of the best kind of clients. And it makes it very difficult for the attorney to kind of navigate that field. I believe, though, more than anything else, what happens is that attorneys forget that the law applies and that there is law involved in custody. So that's a little bit about what we're talking about here. Deal 2006 held that custody was the right and responsibility to make decisions with long-term implications for child's best interest and welfare. So I think it's important to put that into perspective, that in general, that's what the law was thinking about, is that the person who has the custody rights is the one who's making those long-term decisions for the children. And I think that that's what you need to emphasize in the issue of what custody is. And just tell me, so like what you're worried about is physical placement of the children. Custody is important, but what is the physical placement? In 2015, North Carolina enacted 15-13.01 that clarifies the court should always look away to equally divide custody, showing preference for split custody orders. So at least since 2015, and probably before that, courts have been thinking in terms of split arrangements. And I think that some people would say that you have a statutory duty, judges do, to try to split that time as equally as possible. So because of that, we certainly have seen sort of a shift in the law in terms of how we go about it. But to break it down, the very first, I think, most important piece of what starts custody cases is whether or not is there an emergency custody order requirement. And that you'll find in 15-13.5 saying that a temporary order for custody which changes the living arrangements of a child or changes custody shall not be entered ex parte and prior to service of process and notice unless the court finds that the child is exposed to a substantial risk of bodily injury or sexual abuse, or there's substantial risk that a child might be abducted or removed from the state of North Carolina for the purposes of evading jurisdiction in North Carolina courts. So, in the beginning, I think that custody orders are supposed to be very specific. It's not supposed to be a situation of, hey, I think dad smokes pot. That doesn't necessarily lead one to believe that there's a substantial risk of bodily injury. And a lot of courts have found that just because there's violence against mom doesn't necessarily mean that automatically imposes a risk of substantial injury. So a lot of the things that our clients are going to come marching into our offices and demanding emergency custody for are going to be things that we have to determine whether or not that rises to that level of substantial bodily injury. Now, I personally think that this is one of those situations of zealously representing the client or being an officer of the court. If a client asks for emergency custody, should we file for it? Just on that alone. And I think that, like a lot of things in law, obviously the answer is going to be, it depends. But I think that the thing for us is to be able to guide that. Our relationship with the court is long-term. And if we're always crying wolf, then I think there's an issue that we're going to have in terms of credibility long-term with the court. But at the same time, if we get these orders, then it makes it to where it's almost, we have a duty to go and request them. In general, I would just say, grab another member of the team and just say, like, okay, out of the context, you haven't heard this, the consult that I just went through. But here's what I've got. Do you think I have enough for emergency custody? I think that our newest tool in that is our family practice area text group. One is to just text each other and say, here's my issues, here's what I think, and then here's my judge. Okay, let's see if we can use that little pause to get anybody else on. So with emergency custody, you want to make sure that what you're doing is balancing with our practice area group. Is this enough? Do I believe that other people would find this to be enough? And then take into account what the court, which court you're going to be dealing with, because I think a lot of times what we're trying to go up against is, what does that one particular judge think is an emergency? Is it something that they've done in the past? And know that some judges, I feel like it changes a little bit from day to day as to, well, today I'm a little bit more apt to sign one, other times I'm not. And I think that there's that becomes a ongoing kind of issue in terms of what that may be. People in. Okay. In an emergency custody situation, you need to be able to define what a substantial risk of harm is. Sometimes you can do a little bit of selection of which judges that you're looking for, but a lot of times you're just going in front of the judge that is presiding that day. And I think that becomes one of the sort of issues that you're dealing with first, whether or not that judge is going to sign that order. One of the things that I note here that I think is very important is you need to tell the client that when you're going for emergency custody, this is going to be the best day of your case. Because I believe that what happens is our clients see us get an ex parte order for emergency custody, and they think that we hung the moon, that the judge now believes in their case, that they are going to have full custody all the time, and that finally that a judge has seen through all of the crap that they were dealing with, and now they've got this good result. The reality is it will never be as good as what they're getting under that emergency custody order. That almost immediately the judge is going to turn on that client and say, okay, you got your emergency custody order. You better have been right about what that emergency was. And I think that puts you in a bad spot. And sometimes it can actually hurt you in the long term of the case, because the judge will be like, well, you got that emergency order. I see the other sides here. They seem like they're fine. You pulled one over my eyes, and now I'm going to kind of take it out on you later. So clients are like so happy that they get that 1 week of full custody or whatever it is, and for that hearing, and it ends up putting them in a worse position. And one of the reasons why you say, like, well, maybe I could get an emergency order, but is that really what you want? Isn't it better for us to be able to present the facts and be able to get whatever it may be? Most of the time you want to just kind of cover it. But I want to read to you this end of this case of Lamb v. Lamb. And this was for Rule 11 sanctions due to the actions of an emergency custody. Rule 11 sanctions. So every attorney kind of peeks up and listens out. The motion for emergency custody order hearing was without basis in law or in fact, and was interposed for an improper purpose. Said motion was dismissed upon the motion of the plaintiff at the conclusion of defense evidence for lack of sufficient evidence to support the claim stated therein. In addition, said motion was filed for improper purpose, i.e. to block plaintiff's scheduled summer visitation. Therefore, plaintiff is entitled to recover attorney's fees incurred in the defense of the motion. Plaintiff's attorney incurred 14.11 hours in defending the motion. Said number of hours was reasonable, $250. So there was a sum of $3,500 attorney's fees incurred for defending the motion. Custody order was reasonable and necessary. That's Lamb v. Lamb. Why did I put all that in there? As a reminder before you go and get an one, especially if it's like so timed. And believe me, that timing is not unusual in these cases. Well, he's about to get custody back. So now I found an emergency coincidentally at that same time. This is the result, and this is what you can read to the client. And, more importantly, the flip side of it, if a client comes in and it has been an emergency custody order that they've been dealing with, use Lamb v. Lamb to get attorney's fees and say like, well, look, this is exactly what happened. If you feel like your client's been taken for a ride on an emergency order, then do not be afraid to use this case from 2011, relatively new case, but established enough in law that I think that the court would make that kind of finding. So I believe it's an important piece of emergency custody. In the end, the thing is that you as a attorney do not have enough time to do a full investigation for an emergency custody. You don't. You have to do it quickly or not. But it just like Haley started off today with a client, it's like 4.5 months later. The Lamb v. Lamb, that's a perfect example of saying like, look, you're trying to tell me it's an emergency. It's been that length of time. I feel like that if we go in front of a judge at this point, it is off camera. I talked to about, there may be delay reasons because the client just couldn't afford an attorney and it took them a while to get it together, to put the pieces together, whatever it's going to be. If that's the case, put it into the pleading, put in, so yeah, we know it's a delay. Because if the judge hears one piece of evidence that they believe was not told to them ex parte, because remember, your duty in front of a judge is different in an ex parte than it is in a regular case. In an ex parte, you have to give the judge all salient facts, but on your side or against your side. That's what our ethical duty is in an ex parte. So if the judge hears for the first time at a return hearing that, lo and behold, this child had been gone for 4.5 months and you did not put that into your pleadings, the judge is going to be pissed and you're going to lose a lot of face, possibly credibility with that judge moving forward. And I think that's a serious breach of our duty. And I think it affects our whole law firm if we are known to be a firm that asks, everything is an emergency. So you want to be very cautious about using that emergency too much. At the same time, you make your argument, you do what you can on the points, and you try to get what it is. And I try to be very careful when I'm dealing with the judge on an ex parte to say, Your Honor, I don't know everything this client retained this morning, so I feel like this makes sense. It does seem to fit the facts, but if this is true, then. And some things like that, because, you want to make sure you separate it a little bit from the judge. To me, a judge is going to be a lot more lenient on us going into it than going out. Now, one thing I wanted to point out, 15-13.5 does not require a return hearing. Most judges interpret it as being a Rule 65 injunction. But it is, an ex parte is a temporary custody order. It can last for longer than 10 days. Judges just do that because they consider it like I said, like a Rule 65 injunction that requires for a hearing on the merits within 10 days. You can get an ex parte for a length of time. Now, generally speaking, the judges will put it back on, and they like to schedule the return within 10 days. But if it's not been served, or if there's some issues or whatever it's going to be, the judge can just simply renew it, and they don't have to renew it for less than 10 days. In fact, a lot of times you'll see a judge say like, well, I'll put an ex parte in for 10 days. And if there isn't a response, then they'll notice it out for 30 days more or something like that. They're not going to continue to hold it as being like like you would have to in a TRO, where you could only do it for 10 days at a time. That's pretty much my thoughts on ex partes. Just remember, when you come back into court, if the judge does schedule a 10-day, they almost always are going to undo that emergency custody. They're going to say they may enter a temporary order, and that's the way I would treat it. In fact, I didn't put this case, I don't think, in there. It may come up in just a little bit, but there is a case law that says that a judge can then enter a temporary order. So what I mean by that is the judge could find that there isn't an emergency custody anymore, that it's no longer a substantial change, but still enter in a temporary order. Does it make sense? That you don't have to find the emergency exists, because the court always has jurisdiction to make a new temporary order.
That gets confusing. If you had a new filing, obviously temporary order, but then you have a motion to modify and then a temporary order. From there,
Yeah, the judges should be finding, anytime there's a current order, should be finding a substantial change of circumstance exists to do a temporary order. The problem that you run into is that a lot of times judges are just like, I'm temporarily going to enter this in, and they don't go through a lot of the findings or anything else that you normally would do in a change of custody. The reason why that's generally okay is if they label it as being temporary order, it's non-prejudicial and not really appealable. So, I think that the judges do enter those things in, but in theory, you should be, if you're drafting the order, you should say there's been a substantial change of circumstances that are significant enough to impact the minor child to modify the order temporarily. And then you put it in and it has all of those findings. I think the same thing should be on an emergency order and say that, not only is it an emergency, but the court believes that there's enough to show a substantial change of circumstances to modify the current order in effect if the emergency order is on top of another order. Just so you can, because an emergency order, it is considered a temporary custody order, an emergency. It's just that it's done and those specific findings are made. And we'll talk a little bit more about that when we get to motions to modify. Okay, the next thing I want to talk about is third-party and grandparent cases. In North Carolina, that's Price versus Howard. There's not many cases you need to know by name in North Carolina, but that's one you should know, Price v. Howard. That it is, if a parent acts outside or inconsistent with their constitutionally protected right to raise the children, they lose the Peterson, which is another case that you need to know, presumption of their child. Peterson is a it was a North Carolina case, which redefines Troxler case, and Troxler case is the U.S. Supreme Court case that says parents have a constitutional right to parent their children. So, basically, what you want to do is to determine what is. Let's see, I jump into third party. The UCJEA after this cases is to be able to say like, okay, what is what is acting inconsistently with your constitutionally protected rights and status as a parent. Okay, so I can get into more of the case law in just a little bit when it comes to some modification of custody. But let me just talk about a little bit about grandparents' cases and third-party cases. Generally speaking, if a person comes in and they're a third party who is looking for custody of the child, or then you need to be able to show on the pleadings that the parents have acted, they're either unfit or they've acted inconsistent. The easier one would be if it's unfit. That it's, clearly this person is no longer a parent, to be able to do these things or whatever it's going to be. Generally speaking, your only unfit cases are going to be a situation where a grandparent is coming and the children, and they've been raising the child for a very long time. The parent is gone and you're just cleaning it up, because unfit is such a high burden. If there's any question about what's going on, the court's not going to find unfit. The question is going to be whether or not this person has acted inconsistently with their constitutional protected rights. Now, there's been some cases early on where like a same-sex couple was together and because they have a child together, but let's say that one parent is the biological parent. The courts, I believe, have made that a little bit easier for that other party to be able to go in, because they said, well, they've helped them name the child, they've helped them be a part of the child's life, they've taken the child to doctor's appointments and some things like that. Therefore, that person has acted inconsistently with being the sole parent of the child, and kind of, I hesitate to use the word liberally, but have allowed for that to be like, okay, well, that's enough. Now, I don't think that you will find that to be the case as much with a more traditional step parent role, where it's like, oh, well, they sometimes call that person dad or whatever it's going to be. I don't think that you're going to find that quite as often. And then I think that the courts are going to be very different if it's a grandparent that might have been involved in the naming of the child or those things. I think it really kind of comes down to what are the fairness of circumstances to allow for that barrier to be passed. Either way, if you're the third party, you want to put in any factor that shows not just negative things like, oh, this person's a bad person or whatever that goes into unfitness, but to really get into acting contrary to that constitutional act. That, for instance, mom left to go, be to follow the Rolling Stones across America, okay, and left the kids with her parents without any determination of when they would return, no deadline, and no money. Basically, these pawned the children off on mom and dad and took off. I think that on the flip side, you'd be arguing, well, yeah, she went to the Rolling Stones, but that everybody knew she's going to be back in 2 months, and that this was a respite of parenting, and there's never an intent to lose or act inconsistently. This was just a mom who thought the kids might enjoy having summer with the grandparents. These are your back and forth kind of fights. But I think that what you have to do is you have to remember there's two different functions. And I've written a brief on this if this ever comes up. You have to first show standing, and you have to show a relationship to that child that goes beyond just I know that child. You have to be able to show that you have been acting essentially in loco parentis for that child for a significant amount of time. That gives you the standing. Then, and only then, when you have the standing, can you make the argument of whether or not that the parent has acted inconsistently in order to obtain custody. Even though the statute kind of reads it like almost any person can file for custody, you have to first have standing. So even if if Anna is acting as inconsistent with her constitutionally protected status as a parent with her children, I can't file for custody. I don't have any standing to be able to do that. You see what I'm saying? It has to be somebody who has standing first. And I think attorneys and sometimes judges get that confused, because there is first a standing issue and then there's a acting inconsistent issue. And if you can show that they don't have standing, then they don't even get to the question of whether or not your client has acted inconsistent. So I have some pretty good information on that would take advantage of what that might be. Because I've put some home state stuff here, and let me jump across to the next page to the Grindstaff case. A grandparent has alleged unfitness of a parent sufficient to confer standing to seek custody, but the parent is not acting inconsistently if the parent drops the child to the grandparents temporarily In this case, it was a 9-month drop off was not enough. That's Grindstaff in 2002. So if this is a very favorable parent case. McDuffie, death of a parent ends a case and the other grandparent cannot file for custody unless the grandparent shows a living parent has acted inconsistent with the parent's protective status. Limited visitation was not acting inconsistently. So another case in that same year that kind of defines again where parent, it's a sort of parent role. There is a lot of cases on grandparent rights that, in terms of when they can show inconsistency, and you're going to want to go through that, with each one of the cases pretty much in detail. Okay, let's talk about jurisdiction. So the UCCJEA establishes the hierarchy on which state has priority in exercising jurisdiction over child custody disputes. At the top of the hierarchy is the child's home state. You have to determine what the child's home state is. Generally, whatever the home state has the primary authority to grant custody, and a state becomes a child's home state only if a child has lived there for at least 6 months immediately before commencement of the child custody proceeding. It's possible for a child not to have a home state when the child has lived in different states in the last 6 months. If a child has no home state, or if a home state declines to exercise jurisdiction, a state can exercise jurisdiction to make a child custody determination if the child and at least one parent have a significant connection with the state, and there's substantial evidence in the state concerning the child's care, protection, training, and personal relationships. So you can see that directly out of the statute in terms of that. A state which is not a home state or a significant state may nonetheless exercise jurisdiction to make custody jurisdictions if all states qualifying as home states have declined to exercise jurisdiction if a state is not a more convenient forum. And that's the Palmer case from 2019. So here's some more law on that. David v. Ferguson in 2002. North Carolina is the home state when the children and parents have resided there for 6 months. Child leave temporarily with one of the parents, and the child returns to live for 6 months before a parent files an action in another state. Foley versus Foley, 2003. The initial custody determination involving 2 states. The UCCJEA recognizes jurisdiction in only one home state. The parties cannot confer jurisdiction by consent. And if the record does not indicate where the child resided for 6 months preceding the action, the appellate court must vacate the custody order and remand for findings. Blackman v. Blackman in 2008, a North Carolina court with jurisdiction to make child custody determination, the UCCJEA may decline to exercise jurisdiction at any time if it determines that it is an inconsistent forum. Usually that's done by the judges calling each other and trying to make a determination as to what that would be the appropriate place. Walls v. Rawls in 2019. Trial court also erred in finding that it had emergency jurisdiction to enter the child custody determination. A court of the state has temporary emergency jurisdiction if the child is present in the state and the child has been abandoned or necessary emergency to protect the child because the child parent is subject to or threatened with mistreatment or abuse. If children are bounced from state to state, other states have adopted this test. Number one, the duration of temporary absence from the state. Intent of the parties to move will be temporary or permanent, and the totality of circumstances where absence from the state was temporary. I have included a chart that kind of breaks down and explains what and when child jurisdiction is. This chart kind of helps guide you through the process. So, you start with a very basic question. Has there been a valid custody order made elsewhere? If the answer is yes, and a child or a party is in that state, then that state has continuing exclusive jurisdiction. This gets messed up from time to time, but it's kind of like this. If there has been a custody order and in Texas and our client moves to North Carolina, some attorneys will tell you, well, just domesticate the order by filing to have that order. Gosh, what am I trying to say? can't think of the name of the proceeding where you domesticate the order. Anyway, they're register the order. They think if they register the order here, that in 6 months, that North Carolina can do something. But that doesn't mean, registration doesn't mean anything. It doesn't change any of that. As long as if they move from Texas and there's an order in Texas and dad still lives in Texas, that Texas continues to have exclusive jurisdiction, no matter how long that they've lived in North Carolina. Now, if the answer is no, that there isn't another order, or that there's nobody left in that state, let's say that dad moves from Texas, now it's a free-for-all. Then the question is the party or a child in my state? Is there a home state? And has that state declined jurisdiction? And if there isn't, then does the state have a substantial connection? And was it filed in my state first? So if there's two states where there's not a home state, where there is, the child's lived in two states over the last 6 months, then the question may be, who filed first, and in which place is it going to be? Is a substantial connection going to be? So this is a very basic kind of one to kind of go through and get you an idea about going through the UCC JEA. I don't know if it probably was a finish. Patrick may have some things to add about that. Actually, it's probably as good a time as any. Do we have any comments? Anybody want to talk anything about the UCC JEA? Patrick, you want to say anything to it?
Well, yeah, can you hear me?
Yes. We can hear you.
Okay. UCC JEA is super fun. You get to feel like a lawyer when you get to go in and make these types of arguments. And they can really, really change things. Not always, right? I mean, even if something is heard in one state and not in North Carolina, the analysis is most likely always going to be the same, best interest of child. But sometimes there are certain presumptions in other states that we don't have here in North Carolina, and you can really, really do a solid for your client. And it's not that we're doing anything other than recognizing what the law is. People miss this shit all the time. It's easy to miss it, but if you know it, you're going to do some good stuff. So as you were going through, I was going to say one thing that I had recently in a case was the temporary absence. So when you're looking at home state, a period of a temporary absence is included in the calculation, the 6-month calculation when determining a child's home state. And North Carolina has that totality of the circumstances approach. No formula as whether or not this is a temporary absence or something more than a temporary absence. North Carolina has, I think there was a case back in the early 2000s where someone was gone for over a year, and just based on the circumstances, the court said, well, that was a temporary absence. They were looking at a 3-year block, and the child was out of North Carolina for over a year leading up to the filing. So just keep this in mind when you are filing or when something has been filed, especially these counties. Really, all of us are near another state, And we all have those cases where kids going back and forth, moms in North Carolina, dads in South Carolina or Tennessee or whatnot. So study the chart, because all the judges have those charts in their on their desk. Brian's got the chart. School of Government has a chart. I know Judge Scott keeps that School of Government chart on his desk at all times. So print out the chart, study it, and you'll catch stuff. You'll catch stuff.
Yeah, I always call that chart the centerfold of the family one, because it kind of opens up, really big. It's right in the middle of the family line one. And they follow it, and they are scared to death of getting it wrong. And they will sometimes, I believe, make mistakes because of that. They use they get kind of fearful about doing something. And I think a lot of times they just are like, well, I just got to take this on myself. And a lot of times that is not the right answer. It's just the judicial preference in general, that they just think that's what I'm supposed to do. And that gets them a long way.
Let me say this too. When you spot a jurisdiction issue, ask for the court should do it, right? The court should conference if you bring it up. But ask for a UCCJEA conference. And according to 50A, according to UCCJEA, you are entitled to be present at that meeting that the judges have when they talk amongst themselves about which state is the one that should be exercising jurisdiction. You're entitled to be there. Or if you can't be there, you are entitled to be able to present a brief prior to. Because a judge will say, Patrick, I can't even get, two lawyers. I can't even get two lawyers together for an hour without, a primp setting. I'm supposed to wait for you and opposing counsel, and now also some other lawyers in another state and a judge in a different time zone. No, I'm not gonna wait on you to be there. I'm just gonna do this when I find it convenient. If that's the case, the judge has to let you know when it's happening so that you can present a written brief. And do it. I did one many moons ago when I first started practicing family law. And I knew the judge was getting it wrong. And actually on Brian's advice, I was going to brief it. I wanted to brief it. On Brian's advice, I put a certificate of service on my brief. It said, hand delivered to Judge Britton. Signed, Patrick Bryan. Because I knew what Judge Britton was going to do, and I was trying to give him a brief. He said, go stick it in my box. I'll read it later. I was like, no, I need you to take it right now. And so I gave it to him. He had already made his decision. And by the way, that ended up getting undone. Roundabout way, it wasn't even undone by North Carolina appellate court. It was undone by California appellate court. Strangely enough, it's a long story, but do that. And just a general piece of advice is everyone should practice and become okay with being able to tell a judge is wrong. You got to have tact in doing that. You got to have respect in doing it, but judges do not know everything. They don't, and it's okay, and it's our job to tell them when they're getting it wrong. So don't be afraid to tell a judge, with all due respect, that's horseshit.
Well, and I think that the point to that is what you're getting today, whether you're in the room or whether you're listening to this recording, is more than what any of those district court judges got going onto the bench. They don't get special training. They go to judges school, which is divided up in a lot of different ways. Most of our judges are from the DA's office. That tends to be the way you become a judge. And it is not an easy to jump over that hurdle. And I think that the UCC JEA in particular feels like jurisdiction like they dealt with in criminal court. And it's nothing like it. It does make it difficult, and they have to work. I think Patrick, not too long ago, organized 2 judges to talk, which is a Herculean feat as being part of it. And I know that I believe Patrick feels the same way I do. And that is, although it doesn't specifically say that the attorneys are going to be present, I feel like that the attorneys need to be present during that phone call, or at least I want one of us in that room, because the judges will talk themselves into something wrong. And I believe Patrick could probably speak a little bit as to that particular part, because there's a little bit of an art of getting those judges together.
Well, yes. You just gotta ask for it. If they're not doing it, you gotta ask for it and calendar it on like you would anything else. That's about as good as you can do. In this case I had recently, I was working in tandem with a Tennessee lawyer. So it's fun when you get to do these things. I had another one where referencing the California case. It's working hand in hand with a California attorney, hand in hand with a Tennessee attorney. So everything that I do was in a certain strategy and in line, and after communicating with that attorney. So as most recently, I tell Chris Raines over in Kingsport, Tennessee, the attorney representing our client over there, I said, look, I need you to file. When you file, ask for a conference. Let me know when you file. I'm going to file a motion to dismiss on the day that you file in Tennessee. Send me a copy of it. So he does. I file my motion to dismiss same day and also ask for a UCC JEA conference. He goes and talks to his judge about when he could actually do it. I get those times and dates from him and then share it with the little coordinator for Judge Dre. And then Judge Dre picks one of those dates and we do it. I wouldn't have been able to do that by myself. I had to have the lawyer in Tennessee. And same is true for the big one I had in California. Was a lot of fun. I went up to the Court of Appeals in California. Some old bald-headed guys in San Francisco said, hey, Patrick got this right. And talk about an ego trip for a little piece of, white trash from rural Alabama. I think some geezers in San Francisco said that was exciting for me. But the lawyer out there was great. And working hand in hand with your co-counsel in the other state is imperative. Because you also can, what I did with this Tennessee counsel was I said, hey, UCC JEA conference, here's what I want you to handle. I want you to say why Tennessee is the right place, and I'm just going to say why North Carolina is the wrong place. And you can tag team the argument. It's a lot of fun. It's a whole lot of fun. And now we've got a referral source out of Kingsport. So and the client super happy.
Hey, you may have been born pure white trash. Fancy, isn't it? Victoria, you said you.
So, and this doesn't have to do with the dual state, I mean, I guess it does. So what happens if you have a client who has a baby that was just born and born in a different state, but is now in North Carolina? So, I mean, and by just born, I mean like 2 weeks old or something like that, and they have moved to North Carolina, been here for about a week. Like what, how do you do that then? I mean, I think it's just a right.
Yeah.
Yeah.
Probably no state has been established.
It's no
I-
home state.
I don't remember if the UCCJEA says anything about under 6-month-old children
It does. It does. It says
where they're born.
where they're born and lived continuously. So
Okay. Oh, since conceived. Okay. Oh, that does sound right.
You deposed Anna.
I do. I remember telling him that he had to go take parenting classes beforehand.
So was that Victoria that asked that question?
It was.
It sounded like it. So if that's the case, then and you're there, and one other parent is in the other state. If you got a South Carolina say child is born in South Carolina, mom, dad, child all live in South Carolina. Mom and child moved to North Carolina 1 week later. Mom files in North Carolina. Dad files the day later in South Carolina. Generally, when there's no home state, first to file is where it's going to be.
Okay.
So if it had been done in South Carolina, generally that's probably who would end up with it. And then there's always a inconvenient form type of analysis that can be done. So, but first to file when there is no home state, generally going to hold on to it. You would have to ask. In this situation, if your client's North Carolina and it was filed in South Carolina and then filed in North Carolina 1 day later, then generally you're going to have to ask South Carolina to let it go so that it could be up in North Carolina. It's whoever gets there first. So when there's no home state anyway.
So I have your one as well, Haley, by the way. So I have a client that just did a consult who wants to do legitimation, child born in North Carolina, all the parties born in South Carolina.
Well, the baby's still here. I mean, it seems like to me North Carolina would be right and under that scenario.
Could you repeat? I couldn't hear any of it. What's the scenario?
Yeah, so conceived in South Carolina, born in North Carolina. Now mom's back in South Carolina. Baby stayed here with third party relatives. Where's dad? And dad's in South Carolina. But the child has been here the whole time. So it seems like to me Still really young, really young. And you're just trying to legitimate this child first and then file for custody. I mean, to me, that's a North Carolina case. I don't think that the mom's movement would make much of a difference there. And child support might be a little different if he were going to deal with that at some point, because mom may not have substantial connection. But I mean, I think, you got a child who's has never left the state. I mean, I think that's a North Carolina exclusive home state jurisdiction.
Yeah, I think you know where the child is, it's like the status of the child, not parties.
You're gonna be dealing with grandparents, Kate, issues, I'm sure, in that thing to make it all happen.
So not related, but I uploaded as a template. The third party custody complaint that I use that's for non-emergencies, so I really like that, has a bunch of examples in there of different things that would be inconsistent with parental status.
Oh, good. And when you say uploaded it as a template. Okay, all right, let's move on. Modification of custody. If there's a permanent order in the past, or it has the effect of being a permanent order, because it's a temporary order that hasn't been heard during that time period. I would say that at that point, what you're dealing with is a modification case where what you're having to show is an impact on the child with a substantial change of circumstances. I got a few cases that kind of redefine as to what that substantial change of circumstances is. And the bench book has a lot of cases on both sides. So there's, and I think this is one where you want to put as much law in as possible. The Ford case in 2005, where findings of fact by the trial court relate to problems that existed at the time of previous orders, the trial court errs if it finds substantial change of circumstances, especially when the only evidence of harm to the child was normal reaction to parental disagreement. Okay, and this has come up in a couple of our cases of like, well, of course, when there is a child custody is modified, it's going to create some impact on the child. But that should not be enough to modify it again. In that same case, evidence of parental use of alcohol is insufficient for basis modification without evidence that the effect of alcohol use has on the welfare of the child. Just listing out mom's bad stuff or dad's bad things is not enough to make a determination overall. The Ravon case, which is unpublished, but I thought was interesting. Even if a parent makes more poor choices in the time since a prior custody order, if the child is doing well and the facts don't otherwise indicate that the change affects the child, there's no error in the court's conclusion to deny a motion to modify custody. So if you're fighting against a motion to modify custody and the kid is doing fine, it really doesn't matter how bad that parenting is on the other side, which is pretty tragic in some ways, but and a brutal result. Warner v. Warner, mother failed to offer evidence regarding of how her substantial change of circumstances affected the welfare of the minor child. The trial court properly denied motion to modify custody. And Jenkins 08, a substantial change of circumstances affecting the welfare of the child existed where the dad had remarried and could provide a stable home. Mom was abusive relationship, and the evidence showed mom could not hold a job and move from house to house. I thought that the Jenkins one, while it's unpublished, is a pretty low bar overall, because all you have to do is say like, hey, dad remarried and got better. Well, surprise, surprise, he wasn't a bachelor anymore. How does that, that would affect just about every man. And then you have the fact that, well, mom's moving from house to house. That seems pretty low, but that was enough. A lot a lot of the motions to modify are unpublished opinions. So, don't be afraid to dig in a little bit in unpublished opinions on these kind of cases. They're only going to be persuasive anyway. You're never going to have a controlling law that says, Judge, you have to find a substantial change of circumstance because of this case. They're always going to be able to be differentiated. So you just want to throw on a pile of cases that you can say, it says like, look, these cases were enough. Because if you're the one that's wanting to show a change, you're going to have to go out of your way to be able to show that you do have enough. And the Facto versus Spire case, it's a brand new one from April of 2021. I thought this one was really good. The changes in the child's medical needs and one parent's willingness to provide for a child's need was a change with a self-evident impact on the child's welfare. You don't hear that a lot. So that's a 2021 case that shows the same change of circumstance that's pretty light, and I think that's a good one. Of course, the same time they did the Henderson case, that the court there failed to make findings directly linking the changes identified to the welfare of the child. So you just have to keep drawing pictures of like the child's having trouble at school, the child, you almost always want to have an expert in there saying like, hey, the child is not doing well because, if you want to get a modification done. These cases are tough. If you are trying to modify, you should really pack it full of law. So it's like, Judge, you're not doing anything that would not create a problem. Cheryl Howe is the person in North Carolina that all the judges go to in terms of family law cases. She has a really good article about when there is enough to modify, and the judges, I promise you, will listen to Cheryl Howe more than they will Court of Appeal decisions. So, I would definitely try to argue that bring that with you to show the substantial change and highlight that case, and say like, look, this is where Cheryl Howe would be on this case. If you can say like, hey, Cheryl Howe would have said that from the School of Government, then the court is going to say, well, then I would have, pretty much every time. Motions to modify are good ways for us to make money and bad ways to make your living in court. It's just hard to get there. You need to, obviously, on all these, know your judges. Is this going to be a judge that's going to be more likely to modify or not? Okay, relocation of a parent. Ramirez v. Barker is the case in this area. 1992 case. You can take a look. If a parent is relocating, you have to go through this 5-factor test. I have not seen a case in North Carolina that did not specifically refer to the Ramirez-Barker standard. You have to look at the advantages of relocation in terms of capacity to improve the child life of the child, motivations of the custodial parent into seeking the move, likelihood that the parent would comply with visitation orders if they're no longer in North Carolina, integrity of the non-custodial parent in resisting that relocation, and the likelihood of a realistic visitation schedule. On December 2nd, I'm going to be doing a CLE where all of the Mecklenburg, well, not all, 4 of the Mecklenburg judges are going to be on my panel. I've been doing this last 5 years. To a person, they all will say, we will not move a child based on relocation of a parent. Now, that's a little bit of Charlotte arrogance, a little bit to it. I don't think that people would feel the same way about Marion or about Hickory even, or something like that. I mean, like, well, there's going to be better job opportunities. You got to go for that. But I think that the judges in Charlotte, in Buncombe, Greenville, they're going to be a lot less apt to move a child. They're going to say, like, look, there's jobs available in our place, and they definitely aren't going to move a child because one of the spouses or one of the parents has a new girlfriend, even a new spouse. I mean, they do not want modification based on relocation. So if you do have it, you want it to be as expanded as possible in terms of why you're your client is moving. And even if you can pass those 5 tests, you want to make sure that you have got a strong basis to be able to make a move. Relocation cases are tough.
A lot recently too is if you have the parent who wants to move and you have majority custody, like the other party only has like every other weekend or 1 weekend a month or whatever, judges will say, I'm not gonna tell him he can't move, but if he, like in my case, I'm not gonna tell him he can't move, but if he does, he just needs to make sure that mom gets her visits. And
Yeah,
my
like,
client
how
is
do you-
down for it.
Yeah, how do you manage, and every other whatever? I mean,
Yeah,
yeah, I think it would be a little bit different if you are trying to move it when it's once a month or something like that. Or maybe if you could come in with an offer to the court saying they will get more time with the child after this move because the children will stay there for summer or something like that. I feel like that would be your much better area. But like I said, I know judges' first reaction is just going to be, no, you know what? You had a child here, the other parent lives here. We're not going to let you move. So, temporary moves might be more possible, school, temporary job, something like that. I think that would probably work. But for the most part, you're going to have an uphill battle. Okay, two more issues I wanted to go through. Wishes of the children, much like Ramirez Barker, is your case on relocation. Hinkle v. Hinkle kind of controls when it's the wishes of the child. That the court must yield in all cases to what it considers to be the child's best interest, regardless of the child's personal preference. The wishes of a child of a sufficient age is entitled to considerable weight when the contest is between parents, but it is not controlling. Okay, so there's no magic age, and it's never going to be controlling. Grissom v. Cohen from 2018. If the child is of age of discretion, the child's preference of visitation may be considered, but his choice is not absolute or controlling. As to what is the age of discretion, we feel the better statement of the law is found at the Amjur 69. The nearer the child approaches the age of 14, the greater is the weight in which should be given the child's custodial parent. Custodial preference. So you can take a look at that. The Grissom case, not too old at this point, kind of gives you an idea. That's again a judge's preference. I have some judges that look shocked whenever I say that I've wanted to have a child testify. I've had judges that feel like I'm not going to make a decision until I've talked to the child. So it is that crazy across the way in terms of the way judges are going to look at this. I feel like that if there's been a trend over the time I practice, it's been judges spend less time with children in terms of making decisions. And I think Frank had a pretty good TikTok on this week where he had his child convinced that her birthday was yesterday. And even though it had been weeks before, and she was absolutely adamant that it was yesterday. So it's just difficult to control, to be too much into a basis of what a child says. I feel like, I think I could even go as far as maybe to say that some of the judges that don't have children will listen to children a little bit more than parents that do have children, that are like, I wouldn't trust my kid with anything. So there's no way I will let them make a decision, or just be like, look, this is a parent problem, not a child problem. So we're not going to deal with it through the children. It's tough. Especially when you have a teenage or a preteen wanting to strongly live with your parent, your client, because they're going to be like, I want my child testifying. They know they're the ones who has that information. You'd really like to get that information from a different source if you could, but it's tough. That kid knows what goes on in that house, and you may not. finally, when it comes down to, and I don't think we as a firm have a strong feeling. I mean, I will let you make your call as to whether or not you want to bring a child into it. Just be very, very sensitive to that issue. Try to find out from the judge beforehand, like, say at that pretrial conference, we may want the child to testify in this case. How would you want to handle that? It used to be that the judges did not have discretion. If one side wanted that child to have to testify out in open court, then they had to. Then there's a case law that came along that said that the judge is not bound to make the child testify on the stand. And since that time, I don't think I've seen children on the stand. You guys are out there seeing more. Are they putting children on the witness stand?
No, they're taking them like in chambers or in a different area, and if you don't care if it's recorded, like on record, and you just want the judge to talk to the child, then sometimes they don't even bring the attorneys back there.
Yeah.
But I just had one recently in my Williamson case where it was just me, Garland, Judge Martell, and the child. We didn't record it or anything, and we just it was more of a conversation than questions. But I've seen a lot recently where judges aren't putting them on the stand, but they'll take them into chambers.
What do you see more in Buncombe? Because the children I've had in Buncombe, they put them on the stand.
I've personally, and you can ask, PD might be a better one to answer this, but where unless they're like 15 or 14 or 15 or older, they won't put them on the stand. And I've actually had Judge Scott tell me he's not going to talk to the children in a case when they're under 12. So Patrick Bryan might have a better answer.
What was the question?
Patrick, the question that they're talking about is at least in Buncombe County, is there any kind of general rule about children testifying? Putting them on the stand, talking in chambers with attorneys, without attorneys?
I think it depends on each judge. My experience with Dotson Smith has been she will if somebody wants a child to testify, that poor little kid is gonna be on the stand. Judge Scott has a little stick pony in his chambers. And when he has a child testify, depending upon the age of the child, it may be, let's go ride the stick pony.
Would that stick pony happen to be a unicorn?
It is.
Okay, I was going to say that doesn't sound right unless that stick pony
It
is.
is. It is. It is. Yes.
Okay.
So, and I think I have had a child testify in a Judge Dre case as well. But it was an older child, so I don't think anybody thought much of it, took the stand. But Judge Scott will tell you flat out whether he wants to do something or not. And if you can do it if he says something, if he says, I don't want to talk to the kid, then you're probably best not bringing the kid in there. Unless you know something that the judge doesn't know. But no, I don't think there's a general rule. I think a lot of clients think, I don't know where they've read it or whatnot, but a lot of clients think, oh, my kid can't testify because he's not 14 or he's not 12 or whatever. That's just not true. That's not what the law is. People think there's a magic number there. There's not, right? There's just not. So no magic rule, no magic number. Back to your original question though, Brian, the question that you asked, I'm seeing a lot of everybody just pull up a chair, clear the courtroom, keep the mics rolling. Everybody just pull up a chair around the table, make a little circle, and let's do the examination that way. So
I get judges sometimes not wanting to listen to the child because of the age. And I don't know if they just, I mean, it's the older judges, the ones that have been there for a while. And they need reminding that it's not always about preference, you know, sometimes that child's your fact witness.
Mhm.
Especially as to certain emergencies, that I think they get in a rut. That, oh, you just want this child to say who he wants to live with, or.
I would ask to Victoria, I think I heard you say, and y'all tell me because I don't know, but I would always be reticent to let judge go and talk without it being recorded and without me being back there. I don't know what the benefit would be in that. If the judge is like saying, hey, I'm going to do this, let me do it this way, I just don't trust it.
Yeah, we had a judge that used to do that. And it was basically that I'm going to go and take the judge, take the child with me, and we're going to go talk about it and then come back with results. An unrecorded, just them and the child. It was brutal because you just didn't know, and you certainly, your client's looking at you like, well, why did I hire you if the judge was just going to go and talk?
Exactly.
And I just think that you were trying to divine something out of a child. I mean, I've seen my kids like completely like, oh, Dad, let's go do this. And then by the end of the day, they're just in a different mood. I mean, that's just the way the child is. And, it seems like a big stretch to do that. And, I've seen enough interviews from Departments of Services and things like that to where, I just have some grave concerns about it. And the only problem I've got is like, am I any better off than what the judge is in terms of that? And the answer is no, but at least I'm there to be able to kind of direct what I believe is, well, Judge, are you even asking about this?
Right.
It might be that the reason they don't want to spend the time with mom is because of a stepchild. Well, that may never come up in just an individual discussion back there, but it might be a very relevant thing to the child. And of course, children are probably rightfully going to be hesitant to say anything negative about either one of their parents. That's just kind of the nature of that. So,
and you can't challenge anything. You can't.
Correct.
The judge comes back and says, all right, everybody, that'll do it. I'll issue an order. You'll see an order from me in 3 days. You get an order and it's shit for your client. You can't really fucking do anything about it.
Yeah. I think that your best scenario is, and maybe that's just what we should do as a firm, and just say like, look, it's our position in all of the cases as a firm that we are there present to ask the questions with the child. Now, one of the things that I used to have this debate with Lee Taylor back when she was attorney that I went against a lot. Now she's a mediator for us. But Lee felt like that the attorney should not meet with the child before court, that was just too prejudicial in nature. And I felt like just the opposite. Like I can't go into court without knowing what the child's going to say. And I think that there was a lot of discussion as to that's right, because some of our judges went with the Lee Taylor concept, which came from a partner she used to be with that felt like that was the rule, and he was a family law specialist. So a lot of judges felt that way too. I personally think that we should talk to the children beforehand. And we have to be careful because that's going to be part of the question, and that you really need to make sure the judge knows that, yes, I did talk to the child beforehand. But I wanted to know if what my client was telling me was right or not. And I just don't think that you could go into it any other way. And then, I definitely believe we could say as a firm, we really, Your Honor, it's just our firm always requests to be part of the present in terms of those questions. Obviously, there's only so much you can push against a judge. I've never seen a case that says that a judge cannot take a child and ask questions, because it's very clear. There's a lot of case law that says judges can ask questions in trials. Whether or not they're exclusively asking questions, that cannot be what the rules of evidence presumed was going to happen. In fact, I think that's a completely different kind of court, if that's what actually is going on, where the judge is doing the questioning and the ruling. But I think there's some issues there. All right, well, I won't belabor that too much. These are all kind of issues that will come up in your case. The last one we'll talk about is parental alienation. And there is a lot of discussion amongst family lawyers about alienation. Really, a lot of the questions that you get is whether or not there can be a syndrome associated with it. North Carolina has essentially kind of skirted that. In 2006, the Baker case says, when a custodial parent's interference with visitation comes so pervasive as to harm the child's close relationship with the non-custodial parent, the trial court may conclude that the best interest of the child is to grant custody of the non-custodial parent. So without getting into whether or not it is, that this is a syndrome or whatever it may be, and I've had experts to get into what alienation can be and whether or not that child is alienated or whatever it is. A lot of that science was called into question because of, in part because of the scientists involved in some of those studies. There's no doubt North Carolina will say, look, if you prevent the other parent from co-parenting a child, then you can lose custody over that action. So in a way, it kind of deals with alienation in just a more direct way, that could be enough to impact custody and what a decision would be. Okay, any other questions or anything else? Okay, all right, let's take a pause. We're going to take about a 5-minute break, and we will change this over, and I will change it to a new section.